The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. Constitutional Day is observed each year to commemorate the signing of the United States Constitution on April 17th of 1787. Because September 17th falls on a Saturday this year, we celebrate Constitution Day today. The Iowa Constitution was signed 70 years later on March 5th of 1857. And so it is today that we celebrate not just as lawyers and judges or just those that are involved in the law. It is a day for all of us as citizens of this state and this country to draw together the values and the principles that are found and expressed in our Constitution, and to become a community of people devoted and more devoted to the principle expressed in our Constitution to be a more perfect union. I want to thank the Department of Education of this state and the Iowa State Bar Association for assisting in this celebration today, and we welcome the students from West Branch High School who join us in the courtroom this afternoon, as well as students from across the state who join us through the live stream of these proceedings. There are 3 cases submitted to the court this afternoon. Those cases are Christopher Godfrey versus State of Iowa and others, Kent Langholtz and concerning Harold Brombaugh, and the final case is State Public Defender versus Iowa District Court. That last case is now submitted to the court without oral argument, and we'll hear the arguments in the Godfrey case. Ms. Conlin, you may proceed.
May it please the court, counsel. This case presents an issue that does not appear to be settled in the law of Iowa. The issue is, does the Iowa Constitution provide a remedy in money damages to a person whose rights have been trampled on by the government? This is the issue the court was unable to decide in the Renda case some years ago, and now it's back, this time squarely presented to the court. Chris Godfrey was appointed in 2006 and was in the second year of his second term as Workers' Compensation Commissioner when Governor Branstad was elected in 2010. Godfrey's term as a quasi-judicial executive officer did not end until April 30th of 2015. Governor-elect Branstad sent Chris Godfrey and 30 or so other executive officers a letter asking that they all resign. Chris Godfrey declined and explained why. He was called to a meeting with the governor-elect on December 29th, and the governor-elect once more asked him to resign, and once more he declined. He didn't hear anything further from the governor until July of 2011, where he was called to a meeting with the chief of staff and the legal counsel, and once again asked to resign, and once again he declined to resign. He told the governor's staff, as he had told the governor, this office that I hold is an office that has a 6-year term of years, which means it's supposed to be, insofar as possible, insulated from political influence. That did not impress them, apparently, because the chief of staff then asked him if the governor could get him to change his mind, if he would reduce his salary from the highest level allowed by law to the lowest level allowed by law. And that was, in Mr. Godfrey's case, a decrease of more than 1/3 of his salary. Chris Godfrey said no, that would not change his mind, and before he got back to his office, his salary was reduced from $112,000 to $73,000.
Well, Counsel, don't you have a claim under the Iowa Civil Rights Act?
We do indeed, Your Honor.
And why would you want us to create a claim under the Constitution when you already have an existing claim?
Well, Your Honor, the claim that we have under the Iowa Civil Rights Act is under a statute. We feel that a claim under the Iowa Constitution is much different than any statutory claim. First of all, statutes are at the whim of the legislature, and the Constitution is permanent. It tells us what our rights and our duties are for presumably all time. It can't be changed.
Counsel, there's some case law out there, at least from Vermont and elsewhere, I know you're familiar with it, that stands for the proposition that, well, there may be a constitutional claim, but if the legislature has an adequate remedy, we'll follow the legislature's adequate remedy. Some cases don't follow that fork, but there are some that say, well, if the legislature provides an avenue of redress, we don't need to imply a right under the Constitution. What's your response to that line of cases?
Your Honor, I don't think that you are implying anything. There are two sources of the power of this court to enforce the Iowa Bill of Rights. The first is what we say is the self-executing nature of these two provisions of the Iowa Constitution. And the second is your inherent power to enforce the supreme law of the land, and that is the Iowa Constitution.
How do your two causes of action differ, and in both ways, in proof way and in damage way?
Well, Your Honor, in terms of proof, we have a claim for discrimination on the basis of sexual orientation under both the Equal Protection Clause, which this court has recognized as controlling rights with respect to sexual orientation, and also we have a claim that the governor did what he did for partisan political reasons, which is not covered by the Iowa Civil Rights Act, and if it is not recognized by the court, that particular right would not be enforceable.
Where's that right protected under the Iowa Constitution?
It's protected by the Due Process Clause, Your Honor. That's what we think. We also want the court to be aware that Mr. Godfrey's salary was reduced. Mr. Godfrey was the only openly gay member of this Branstad administration and, frankly, any Branstad administration. And he is also the only person ever in the history of Branstad administrations who has had his salary reduced in any way, and we do not think that is
But we're not here in the merits. I want to probe the sex discrimination claim. You have a claim under the Iowa Constitution related to sex discrimination, and then you also have a statutory claim under the Iowa Civil Rights Act. With respect to liability, are the standards the same under the Iowa Civil Rights Act as equal protection under the Iowa Constitution, or is it substantively, broader or smaller, or where are we?
I think that the Equal Protection Clause is obviously much broader than the Iowa Civil Rights Act, which only protects people as a result from discrimination as a result of their membership in a class. Everybody in Iowa is covered by the Iowa Civil Rights Act one way or the other, but it depends on whether or not the discrimination occurs on the basis of their race or color or creed.
And I do understand that you have a claim related to political or due process that would not be covered by the Civil Rights Act, I take it. But focusing on the claim of sexual discrimination, the argument I think the other side will likely make, or maybe has made, is that, well, the remedy under the Iowa Civil Rights Act is coextensive with a claim based on sex under equal protection of the Iowa Constitution. Is that right? Is that wrong? Help me out.
I don't think that that's wrong, so that would make it right, I guess. But that is not the point that we wish to make. I understand the court's question, and I believe that I've answered it. but that's not enough. That is absolutely not enough to guarantee that these rights will be forever protected, no matter what happens in the Iowa legislature.
If the legislature would repeal the Civil Rights Act, then maybe we might have to take it up. But my question, and going back to my prior question, is, are the causation elements different under your constitutional tort versus the Civil Rights Act?
Well, Your Honor, the causation element is, did what happened to Chris Godfrey occur as a result of his sexual orientation? The same question is asked under the Iowa Civil Rights Act.
But is it a proximate cause, motivating factor? I mean, are there different ways to do it, and are they really the same?
Well, I think they are the same. I think they could be the same, but I don't believe that that's enough. I don't believe that that is what this court ought to do with this extremely important section of the Iowa Constitution.
If you were to win your civil rights action, I'm sorry, if you would win your sex discrimination action under the statute, would you automatically win your equal protection?
I guess that depends on what this court says in connection with this
If we
case.
allowed it, I mean, if
if
we
you-
allowed it, would you win, if you won factually after a trial and a jury, or however you're gonna try the case, on your civil rights action, would you also win on your constitutional or Bivens type action?
I would make that argument, Your Honor. I would say that sexual orientation discrimination is illegal under the Iowa
Okay,
Civil
now
Rights
if you lost your civil rights action under the statute, could you win your constitutional action?
I would make that argument as well.
And tell me how that could happen.
Well, I think that as I said, the constitutional protection, equal protection of the laws, all laws of a common nature shall have a common enforcement, a common application. That's what the Constitution says. And we would say that that is a different and distinct right, but we'd only say that if we lost the sexual orientation.
Counsel,
Civil Rights Act.
in my reading for this case, I noticed, looking at cases across the country, that some jurisdictions that have recognized the implied cause of action set a standard, a threshold. Some characterize it as the violation must be flagrant or egregious. Is that the kind of standard you're arguing for, or what sort of standard, violation standard, do you think we should adopt if we adopt it?
Your Honor, you're quoting from the Utah case. I recognize that. And also the restatement sets standards. But we do not think that that's at all necessary in this case. And we urge you not to adopt any sort of limitations on when these rights can be enforced. And one of the things that many cases say, is that if there's some other statute that you can't have your constitutional action, and we think that is not correct, that is not the way that this court ought to proceed when enforcing critically important constitutional rights.
Well, Ms. Conlin, your constitutional claim or tort is related to the concept of partisan politics, as you've described it. Is that defined sufficiently, or is the concept understood adequately for us to formulate a tort around it based on our Constitution?
Well, Your Honor, there are there's a whole line of cases under the First Amendment that say that there are certain kinds of officers who can't be discharged for partisan politics. And
What does that mean, though?
partisan politics, Your
Yeah.
Honor? Partisan politics means if the governor wanted to get rid of Chris Godfrey because he was a Democrat and the governor's a Republican, he can't do that. That's what those cases say, and that's what we say in connection with our pleading.
Ms. Conlin, let's say at the end of the day in this case, if it's established that the governor didn't reduce Mr. Godfrey's salary because of his sexual orientation and didn't do it because of his political affiliation, but just did it because he disagreed with the policies being carried out by Mr. Godfrey as Workers' Compensation Commissioner, would that mean you have no claim?
Well, Your Honor, that is not what happened. There was no discussion of his job.
But let's
performance.
assume that set of facts. Would you have no constitutional claim under those
No,
circumstances?
I think we would not have a constitutional claim under those circumstances, though sometimes this court is more creative than I am about these aspects.
Well, you don't see a property right in his employment.
He does have a property right in his employment. He has a property right in his salary. He's been getting that salary for 5 years, and he has a property right in that salary. We make that argument.
Going back to the sexual discrimination case, not the partisan politic part of the case, does the Iowa Constitution give your client greater rights than the Civil Rights Statute?
Yes, because it gives him permanent rights not subject to the vagaries of the changes in the legislature, not subject to who controls the legislature.
But the legislature hasn't changed the statute, so, I mean, today, does it give him more rights, or does the statute give those same rights?
Well, right today, as I have indicated, I cannot think of what would be different about the constitutional enforcement. There may be something that I've overlooked, but my argument is we should not be relegated to relying on the Iowa Civil Rights Act. We have a constitutionally...
Didn't Bivens come about, though, because there was no real way to vindicate federal rights, and, you know, then we get 1983 later, but the whole genesis of that implied cause of action was because there was no other way to vindicate rights, and you have another way, I think, at least for one of your claims. I don't know, the other claims, I think, separate.
Your Honor, you are in fact correct that Bivens came about because there was no way to enforce the cause of action against the federal government.
You think
under
the Supreme Court would have done Bivens if 1983 wasn't in effect, or if there were statutes like the Civil Rights Act?
I like to think that it would, Your Honor. I think that the Constitution is the supreme law of the land, and it is designed and intended to protect fundamental rights of every single human being when those rights are trampled on by the government or the governor, as the case may be. The question of who may enforce a statutory right is fundamentally different than who may enforce a right protected by the Constitution.
Counsel, if we did what you asked and recognized a new separate claim under the Iowa Constitution, could the legislature then prescribe procedures and remedies and, for example, require you to go before the State Appeals Board or an administrative agency first, set time deadlines, that sort of thing?
Yes, Your Honor. I think that the legislature retains the right to put boxes around whatever the court does, insofar as those boxes don't interfere with the fundamental right. That whatever they might do would be subject to my coming back here and asking you to change it, of course. Thank you.
Thank you, Ms. Conlin. Mr. Peterzalek?
May it please the court, Ms. Conlin? There's nothing in the facts of this case or in the law of this court or in the Constitution of this state that supports or compels this court to create a wholly new and unprecedented cause of action for money damages under the Iowa Constitution. What do you make of Justice Harlan's concurring opinion in Bivens? Very interesting, at least I find it interesting. And what Justice Harlan says is, look, we ordinarily allow equitable remedies for constitutional violations, and we certainly have done that here in Iowa. And if we allow injunctive and equitable type remedies, that necessarily means that actions for money damages are self-enforcing. And we find Harlan cited through the case law, the state case law, not universally because the state case law split, as you know. But isn't Harlan right? If we can enforce a constitutional provision is sufficiently definite to be enforced through an injunctive action, isn't it sufficiently definite to be enforced through a money damage action?
I don't think that that's the case, and I don't think, and that was certainly not how Bivens was decided, ultimately. Bivens was decided as.
Oh, no, but we're dealing with their state constitution. I'm just looking for the best intellectual framework that I can find wherever it is, and it just happens to land in Justice Harlan's lap, I guess.
If you look at our state constitution, which is different in substantial ways from the United States Constitution, in this particular, clearly you could have sought declaratory or injunctive relief, I think, under the Iowa Constitution in this case. But for money damages, if you look and you start with Article 3 of our Constitution, which precludes one branch of government for engaging in powers that are appertaining to another branch, and then you look, because the legislature has already acted in this area. If you look at Chapter 729, which is entitled Infringement of Individual Rights, it has created both criminal penalties and civil penalties, civil causes of action for violations of individual rights. And then you look at Article 12, Section 1, which is one of the issues that we're dealing with here today, that says the legislature shall pass all laws that carry this Constitution into effect. And then you look at the two sections that are at issue here, Article 1, Section 6, Article 1, Section 9, and in both of those sections, right in, I think, the first sentences of both sections, it says the General Assembly shall. So I think the Iowa Constitution contemplates all along the legislature doing this, not the courts. But certainly in Barnum and the other cases, if there's a law or something that's passed that's in violation, you can seek injunctive or declaratory relief. You can seek voiding of the statute, as what was done in Barnum. And I would point out in Barnum, which Article 12, Section 1 actually figured fairly prominently in that case.
Well, the first question in almost, well, not quite universally, but in many of the cases, including those that support your position, the first question tends to be, is the constitutional provision, quote, self-enforcing? And Harlan would say, well, I mean, if we could enforce it, if it's sufficiently definite to be enforced in an injunctive context, then it's sufficiently definite for money damages. And then we move to some other considerations, maybe. This Article 11, the scheduling article, strikes me as dealing with the transition between one constitution to another. If you look in its context, it's all about transferring a debt and so forth, and there's multiple provisions. Why would they put such a substantive, I mean, you're putting a lot of freight on it. Why is that way at the back end while the Bill of Rights is at the front end of the Iowa Constitution?
Well, if you look at Article 12, Section 1, I think the first sentence is any law that is in violation of this Constitution shall be voided.
Sure, any territorial law or any law under the prior regime is void. Sure, transitional provision.
Hugely significant issue, and they said that was one of the bases that Barnum was decided on. The second sentence is the legislature shall pass all laws to carry this Constitution into effect.
All laws necessary to carry the Constitution. And of course, if it's self-enforcing, a law is not necessary.
Yeah, well, self-executing, I think, is actually the term that's used as opposed to self-enforcing. But if it's self-executing, and to be self-executing, not only does it have to provide sufficient framework to allow you to enforce it in some manner, but there also has to be some recognition that there wasn't any intent for the legislature to do something. And in both Article 6 or Sections 6 and 9, the General Assembly is right there in the article.
Let me interrupt for a second. I mean, I think you would concede that the Iowa Constitution provides greater rights than the federal Constitution in many respects.
And certainly in some respects, yes, that's been the case for years.
And how do you vindicate those rights without a legislative statute enabling it? I mean, it seems to me if you're going to say we have greater rights, but there's no way to enforce them, what good are your rights?
Well, you certainly have the right to injunctive and declaratory relief, and you also have a situation where, as I mentioned, Chapter 729, where the legislature has already acted in this area. And I don't know, I'd like to see an example of, in this case, and we are arguing about this case, where we don't have a situation that would compel that such a flagrant violation of someone's rights and is so obviously in need of a remedy as to justify.
That's for a jury to decide whether there's a violation or a flagrant violation. But the question is, if somebody can get injunctive relief, and I go back to Harlan's concurrence again, and declaratory relief, what's wrong with getting damages? I mean, tell me why that is inherently wrong in our system of justice.
Well, first of all, I think, as I mentioned before, I think it presents a huge separation of powers issue, which is recognized in Conlin and recognized in other cases. So, because the legislature's already acted in that area, at least to some extent in Chapter 729 is the example I keep using. But even if you look at the Bivens cases, the more recent Bivens cases, even if there is a remedy even if there's not a remedy available, the Supreme Court has said, well, even though there's not a remedy available, we think this is an area, even though it might intrude on a constitutional right, we think this is an area the legislature needs to speak to, because the Congress is in the best position to determine whether government officials should be held responsible for certain actions, whether they should be held responsible in a way that submits them to a cause of action for money damages.
But hasn't the legislature done that with immunities from discretionary function? I mean, or wouldn't all those things apply to a constitutional tort?
But, you know, that's a question that was raised in Conlin, where if you're dealing with the Iowa Tort Claims Act, you know, it only creates a cause of action for torts that were in existence at the time of the creation of Chapter 669. And is this new tort, is it something that would then implicate the state sovereign immunity? Now, that's an issue too. Number of other issues with Bivens, as with Section 1983 actions. In Bivens, you can't sue an official acting in their official capacity. You can't sue the state.
But those issues, I mean, I admit there's a lot of interesting issues, Harlow-type immunities and so forth. But correct me if I'm wrong, I don't think those issues are before us now. May well be some kind of immunities that kick in, depending on how the record develops and so forth. But correct me if I'm wrong, do we need to confront some possible defenses and limitations of the claim now?
Well, since there are people that are sued in their official capacities in a lawsuit, there's a lawsuit against the state.
But I didn't see any briefing on quasi-immunity and so forth.
I think,
might be there, might not be there. Frankly, I don't know.
yeah,
But
the Amici have certainly expounded on that area. I believe its League of Cities brief does expound on that area quite substantially.
can I just ask you about some of the colloquy we had with Ms. Conlin and the relationship with the Civil Rights Act?
Mm-hmm.
And I've got two questions. First, with respect to alleged discrimination based on sex or sexual orientation, does the Iowa Civil Rights Act provide a full remedy or a comparable remedy to any potential constitutional claim, or is there some kind of difference?
There is no difference. I think that if you look at this court's preemption analysis over the decades, especially the Vaughn case, which actually is directly on point, there's clearly a preemption issue here. There's not a single dollar more in damages, not a single difference in relief that Mr. Godfrey would be entitled to, regardless of which of those causes of action.
But on the due process claim, I take it the 216, the Civil Rights Act doesn't provide a remedy.
I think I understand the distinction. If you look, I think it's at page 129 of the appendix, the plaintiff has all along admitted that the same facts apply to everything.
But I'm interested in facts are relevant too, of course, but I'm interested in legal standard and what relief is available. And as you know, I mean, some of the cases, and Ms. Conlin urges us not to follow them, but some of the cases say, well, if there's an adequate statutory remedy out there, we don't need to double barrel it.
That's the case here.
Well, it is. It might be the case on the sex discrimination claim, but maybe not on the due process claim.
As noted in our brief, there's a cause of action pending in federal court on exactly that claim, political affiliation. He has a remedy under Section 1983, and he's
But I think that doesn't the remedy have to be a state remedy rather than a mixing and matching with federal law?
Not under, if you look at Bivens and the state laws that are state cases that have developed after Bivens, the answer is no, because as I mentioned before.
But a state constitution can't be enforced in a 1983 action.
That is true. It has to be a violation of the federal constitution or federal law. So he has a remedy, so I think we can agree on that.
An unsuccessful remedy.
It's just not a remedy under the Iowa Constitution. And Ms. Conlin acknowledged something, and one of you folks made a point of this. Where in the Iowa Constitution is this? this right to a cause of action for political affiliation. Under the U.S. Constitution, if you look at the cases that develop from that, they're typically First Amendment claims, often arise when a deputy sheriff runs against the sheriff or
But if
for
we were to
election.
find that the Iowa Constitution has greater protection than the federal Constitution, you can still lose your 1983 action in federal court. And if you don't have any action in Iowa, how do you vindicate those greater protections?
Well, I think if there were a situation, it might be greater protections under the Iowa Constitution, but I don't know, I don't see how that is the situation in this case, which is what we're deciding here today. What right would be more protected under the Iowa Constitution than the federal Constitution? Quite frankly, if you look at the claims for political affiliation, I think there's substantially more protection under the federal Constitution than there would be under the Iowa Constitution. Plus, it was pled under the Due Process Clause, and you have a situation where whether you look at federal law or state law, there's a huge problem with whether there's a property interest, there's a huge problem with whether there's a liberty interest.
Well, okay, I mean, let's explore property interest. I don't know whether there is or isn't a property interest, but we do have Board of Regents v. Roth and all this, and the progeny that kind of suggests that, you know, if you're a university faculty member, it looks like you've got a property interest because you can only be fired under certain circumstances. As I understand Godfrey's claim, he's claiming he has a statutory term, and that he doesn't serve at will, and that any effort to terminate him or retaliate against him is an invasion of his right to ongoing employment for his term, I gather.
Well, one thing, he's never lost his job in this case. That's not an issue. If you look at the cases where there is a property interest, they're termination cases. They're cases where a person
I think
has
that
lost
makes a
their job.
difference. I mean, if you take a faculty member and say they get 200,000, you bust them down to 71 or something, or really, let's take the facts here, a 30% reduction in salary, based on a totally arbitrary reason in my hypothetical. You think that would not create a due process problem?
It does in this case because of the statutory nature of the range of pay that the governor has the sole authority to set. He could set it, in this case, because he believed there was poor performance. He could do it for other undefined reasons that are actually in that statute. It's just one of the enumerated reasons. So no, he has a property interest in that range. As long as he's paid within that range, I would not disagree with you at all.
What if he lowered it because of political affiliation? Is that a proper purpose?
Is that a proper purpose under the statute? Yeah, you know, that actually is a very interesting question when you look at it.
Well, that's why I asked it.
Yeah, so, because, you know, by law, under Chapter 86, and you compare it to some of the other sections, that's, even though it's a term of years, it's a political appointment, and you can consider political affiliation in appointing a person to that job. Other sections of the Iowa Code, like Chapter 80 for the Public Safety Commissioner, you're expressly prohibited from considering political affiliation. So it's a political appointment. So to ask him to do that for political reasons because you're a Democrat instead of a Republican or vice versa, as long as you're getting paid within that salary range, I'm not so sure a
But don't
property
you
interest is
think
implicated.
the reason it was for a term of years is to, you know, the workers' compensation is supposed to be fair, it's supposed to be impartial, it's supposed to, you know, oversee the laws for our most vulnerable workers here who get injured on the job. You know, the grand bargain we made years ago about getting rid of tort actions and allowing workers' compensation, and then the politicized, that adjudicative function for these people isn't, I mean, can't we agree that the 6-year term was to insulate that office from those politics as people changed?
I think it was, you know, my take would be that it was put in place for consistency over a period of time, so you're not just willy-nilly changing how things work back and forth. And if you look at Chapter 86, you have 86.1, which doesn't have any prohibition at all on political affiliation. Then you look at some of the sections that come after that, and I think the statute clearly contemplates there being political influence in the process because the governor's office is required to keep track of who recommends who for the position. So I think it's really an issue not of there being political influence, but an issue of there being transparency and keeping track of who the players are, so to speak. So no, I don't necessarily disagree that this is a position that's completely free from political influence. I think it's very much part of the political appointment process. I'm not sure, am I counting up? I think I am.
Yeah, you may sum up.
Well, in summary, really, the points I'd like to key on, and I think I'm going to go back to the beginning, is I think that as Conlin, which is the Court of Appeals decision that decided this issue and determined that there wasn't a cause of action for money damages, hit all three of the issues right on the head. There isn't any support in the Bivens law for it. There isn't any support in the express language of our Constitution for such a cause of action. And importantly, in Article 3 of our Constitution, and you look at what the legislature has already done, Conlin also recognized a huge area where there is a separation of powers problem. They hit all three of the problems right on the head, and I think that in an analysis by this court, I would certainly encourage you to come to the same conclusion. Thank you.
Thank you as well, Mr. Peterzalek. Ms. Conlin may present your rebuttal argument.
Let me start with Conlin. It was a case pled under both federal and state constitutions. The issue was never the issues that are present here, due process and equal protection. The court is obviously not bound by a decision of the Court of Appeals. It has unique facts, and it is just simply not well reasoned in our opinion. Earlier, we talked a lot about whether or not having a tort remedy or a civil rights remedy by statute is enough. And I think that one of the things you must consider in this case is what harm is intended to be redressed by a law, a statutory law, versus the Constitution. The government can do damage magnitudes greater than any individual can do. If the government wants something out of your house and it's got a warrant, it can just walk right in or break in, and that cannot be done by a private individual.
Can you tell me how your due process or political affiliation argument differs under the Iowa Constitution than it would under the federal Constitution? I mean, what more does the Iowa Constitution, more protection, less protection, or same protection, and whatever you come up with, and why?
Okay, well, I think that the Iowa Constitution has more protection, or can have more protection, than the federal Constitution. The federal Constitution's protections have been diminishing over the years rather than expanding. There is no, the Wiggins case is a good example of that. The court has chipped away at those rights in several cases, though the case itself is not overruled. It's still good law. So the due process right under the Iowa Constitution, by the terms of the due process right, is broader than the due process right, I believe. In a tort suit, the cause of action is between and among individuals, and a tort suit is supposed to adjust remedies between and among individuals. A constitutional cause of action can never be preempted by a statute. That just doesn't make any sense. And if, in fact, this court is going to decide that tort remedies and civil rights statutory remedies are greater than the Constitution, does that render the Constitution a nullity?
Here's, getting back to that language in Article 12, it says, "The General Assembly shall pass all laws necessary to carry this Constitution into effect." Would one possible reading of that provision to be that where the General Assembly passes a law covering an area, that you follow that law, and where they haven't passed a law in that area, then you can pursue a claim under the Constitution potentially. And you have two separate claims. You have the political affiliation and the sexual orientation. There is a law on discrimination against sexual orientation, right?
Yes, Your Honor.
And isn't that a plausible reading of this language, shall pass all laws necessary to carry this Constitution into effect?
Well, it is a plausible reading, Your Honor, but in fact, we think that all laws necessary means necessary, and we do not think there are any laws necessary, and this court has never held that there are laws necessary to carry out the provisions of the equal protection provision of the Iowa Constitution. Barnum is a very fine example of this court enjoining the actions of the state government, the county government, in connection with the issuing of marriage licenses. And there is, frankly, no enacting clause. There's no place that says you may do that.
There is, I mean, this fundamental difference between the Constitution as a source of injunctive relief and as sort of an obstacle, as a way to block the implementation of unconstitutional acts or unconstitutional statutes. Between that, on the one hand, and what you're seeking here, which is an affirmative damages remedy, right?
Well, Your Honor, Justice Abel mentioned Justice Harlan's concurring opinion in Wiggins, which deals exactly with the issue that the court is raising, and concludes that those are rights that are coextensive. And one of the things I forgot to mention earlier is that Title VII of the federal statute, Title VII, the Equal Employment Opportunity Act, coexists peacefully with rights under the 14th Amendment, due process and equal protection rights under the 14th.
Counsel, following up on Justice Mansfield's question and referring specifically to Article 12, Section 1, the language about legislation to carry the provisions into effect, of what significance is it, in your view, that Article 12 is titled Schedule?
Well, I think that's a very interesting point. And I think that, I think that there's a provision someplace that says titles don't count. But I think that the fact is that when that, in 1857, when they were discussing this issue, what they wanted to do, first of all, was to say the Constitution is the supreme law of the state of Iowa. But then they put the other provision in there, I think, because there's so much about schools and taxes and things of that sort. That was really the purpose of that section. And the Bill of Rights is different than every other section of the Iowa Constitution. It's far more important, and far more important that this court not avoid a decision with respect to whether or not the Constitution provides such remedies.
And as if you put yourself in the position of the drafters, might they have been anticipating that there might be some legislation necessary to facilitate things like ratification and
Yes.
and that sort of thing?
Sure, I think there are
Elections.
Yes,
Yeah.
elections and taxes and school board stuff. May I sum up, Your Honor? Thank you. A concurrence in State versus Short emphasizes the importance of independently enforcing and interpreting the Iowa Constitution, and says a court that ignores these distinctly human ends like liberty, equality, and human dignity can only accomplish injustice. We ask the court to do justice.
Ms. Conlin, thank you. The Godfrey case then is submitted to the court for resolution and will remain on the bench but be in recess for a minute to allow the students to leave and anyone else